What looks like an ordinary traffic stop is, from a legal perspective, a carefully structured encounter governed by constitutional standards, judicial interpretation, and documented narratives. Most people experience it as a brief interruption. Flashing lights, a uniformed officer, a few questions, and then a return to the road. But the legal system does not see it as informal. It treats a traffic stop as a temporary seizure, one that is justified only for specific reasons and only for a limited period of time. Every word spoken and every movement made during that window can later be examined through legal reasoning that is far more exacting than the situation feels in the moment. This discussion is purely educational. It explains how courts and legal systems evaluate roadside encounters, not how anyone should behave in a specific situation, and not as legal advice. Laws vary widely, and outcomes depend on facts, procedure, and jurisdiction. What matters here is understanding how legal meaning is constructed. The law is not primarily concerned with how cooperative, honest, or well-intentioned someone feels they are being. It focuses instead on what was said, when it was said, how it was recorded, and how those details fit into established constitutional frameworks. That difference between lived experience and legal interpretation is where many misunderstandings begin. The first place this gap appears is often in the opening question of a stop, when an officer asks whether the driver knows why they were pulled over. Socially, this sounds like conversation. Legally, it is an opportunity for the creation of a narrative. Courts give significant weight to statements made during traffic stops, especially when they appear voluntary and are recorded in an officer's report or on body camera audio. When a driver speculates, apologizes, or explains before an alleged violation is even identified, those words can later be treated as admissions, even if the speaker never intended them that way. This is not because the law assumes bad faith, but because legal systems rely on documented statements to reconstruct events after the fact. Judges and prosecutors do not experience the stop. They read about it. In cases where firearms are lawfully present, this dynamic becomes more sensitive. The presence of a weapon, even a permitted one, often increases scrutiny, not as a moral judgment, but as a matter of officer safety doctrine and risk assessment. Over-explaining, filling silence, or attempting to preemptively justify behavior can unintentionally shape how the encounter is described in official records. Courts have repeatedly upheld enforcement actions based not only on what an officer observed, but also on what a driver said. From a legal reasoning standpoint, the safest narrative is often the narrowest one, responding accurately without adding facts that have not yet been alleged. This illustrates a recurring theme in constitutional analysis. The law rewards precision, not enthusiasm. Good intentions do not erase poorly framed statements once they are written down and evaluated later. Physical movement during a stop is evaluated through a similar lens, but with even higher stakes. Constitutional law allows officers to interpret certain movements as potential threats, especially in the confined and unpredictable environment of a roadside stop. This principle comes from long-standing Fourth Amendment case law that prioritizes safety during brief investigative detentions. The legal concept is not about whether a movement actually was dangerous, but whether it could reasonably be interpreted that way at the time. This is where narration becomes legally significant. When actions are preceded by clear verbal explanation, they are less likely to be characterized as sudden or suspicious. In legal analysis, unexplained movement and explained movement are not the same thing, even if they involve identical physical actions. Once an officer articulates concern about perceived danger, the law permits a wider range of responses, including additional detention, limited searches, or request for backup. These decisions are later justified by how the encounter is described in reports and testimony. Importantly, courts generally defer to an officer's contemporaneous assessment if it appears reasonable on its face. That is why documentation matters so much. Body camera footage, audio recordings, and written reports become the primary evidence of what occurred. In that environment, silence can be ambiguous, and ambiguity is rarely interpreted in favor of the person being stopped. This is not about fear or paranoia. It is about understanding how legal standards classify conduct. A calm, clearly explained action fits differently into constitutional analysis than an identical action taken without context. The law does not infer intentions generously. It evaluates observable behavior against established thresholds. Consent and search authority form another area where everyday understanding often diverges from legal meaning. Under Fourth Amendment doctrine, consent is one of the recognized exceptions to the warrant requirement. If consent is given, officers do not need probable cause to search. The critical detail is that consent must be clear and unambiguous. Courts have repeatedly found that hesitant, qualified, or unclear responses can still amount to consent, particularly if the officer proceeds and the individual does not clearly object. From a legal standpoint, saying yes, saying I guess, or failing to clearly refuse can all have the same effect. Once consent is established, anything discovered during the search is generally admissible, even if the person later claims they did not understand the consequences. This is why courts focus so heavily on the exact language used. The law is less concerned with whether someone felt pressured, and more concerned with whether the record shows a clear boundary was asserted. Refusing consent does not stop an officer from acting if they have independent legal justification, and it does not accuse the officer of wrongdoing. It simply preserves the constitutional question for later review. If a search occurs despite a clear refusal, that refusal becomes legally important when courts decide whether evidence should be excluded. This illustrates a broader principle of constitutional law. Rights are often protected only when they are clearly asserted. Silence, politeness, or discomfort do not automatically preserve them. The legal system operates on explicit signals, not implied ones, and that distinction explains many outcomes that surprise the public. The final concept ties all of these elements together: the duration and scope of a traffic stop. Under constitutional law, a stop must be limited to the time reasonably required to address the reason it began. Once that purpose is complete, continued detention requires additional legal justification. Courts examine this closely, but they also look at whether the individual clearly indicated that they believe the stop should have ended. Casual conversation after the original purpose is resolved can be treated as voluntary interaction, even if the driver subjectively felt they were not free to go. Asking whether one is free to leave is not a challenge or an accusation. It is a request for clarification of legal status. That clarification matters later. If the answer is yes, the detention ends. If the answer is no, the officer must be able to articulate a lawful reason for continuing the seizure. Judges often look for this moment when determining whether a stop was unlawfully prolonged. Without it, the line between detention and voluntary encounter can blur in ways that favor enforcement. This is not because courts distrust drivers, but because legal analysis depends on clear markers in the record. In the end, these four phrases are not talismans, and they do not guarantee any particular result. They illustrate how constitutional frameworks operate in practice. Traffic stops are not judged by how routine they felt, but by how they fit within legal standards governing speech, movement, consent, and time. Understanding those standards does not require confrontation or suspicion. It requires literacy in how the law reasons. When viewed that way, the roadside stop is less about personality and more about structure. And it is that structure, not emotion or intent, that ultimately shapes how the encounter is understood in court.